Hi, I'm Mike Ruger. I'm the managing partner at Greenbush Financial Group. Today we're going to go over understanding wills, health proxies, power of attorneys, and trusts. So as part of the financial planning process we do with clients, eventually we get to the estate planning section, and we'll often ask clients, do you have your will, health proxy, power of attorney up to date? And probably the most common responses we receive is, yeah, I know I've always should have put those in place, just never did. Or we did it 20 years ago when the kids were little, we never updated anything. Or the other one we hear is, if we've got wills, health proxy, and power of attorney, we never did a trust, but should we be considering a trust based on our financial situation? In this video, we're gonna go through how wills work and items you should consider including in your will, a health proxy and how those work, the power of attorney document, the probate process, should you consider building a testamentary trust into your will, what assets pass outside of your will. We're going to cover revocable trust and irrevocable trust. I'm going to give you some estate planning tips, and also we'll cover the cost, like what is the cost to establish the will, health proxy, power of attorney, and maybe some of these trust documents. We'll start out by talking about the most basic document, which is the will. So most people are familiar with wills. If you pass away, they look at your will and see this is who your assets go to. But if you're a parent that has minor children, the will also states who's going to be the guardian of your children if both parents have passed away. Now, when people establish wills, there's usually one of two ways they go. So the one is they engage an estate attorney that walks them through establishing the criteria within the will, or some people are comfortable with the do-it-yourself method, which is more of using a LegalZoom or one of those platforms to really establish your own estate documents. Now, the reason why we typically direct people to the estate attorneys is if you think you're simple and straightforward, that listen, if something happens to me, everything goes to my spouse. If something happens to both of us, everything goes to the kids. It's nothing special. But you might forget to ask yourself some questions, because if you have, let's say, minor children and something were to happen to both parents, and let's say there's life insurance, houses, retirement accounts, and then all of a sudden, if it's a simple will with nothing special about it, when those kids turn 18, they can come into a huge lump sum of money. Maybe you don't want your kids coming into a few $100,000 or $1 million at that age, because they could decide not to go to college, to try and start a business, and it fails and they burn through all their inheritance. They could buy a Corvette. Like maybe you don't think an 18-year-old child will make the best financial decisions, so you have to put some restrictions in place, which is some of the more advanced planning to consider. I'm going to pause for a moment and actually talk about the probate process. So when someone passes away, usually their estate has to go through probate, which is a legal process where essentially they take an inventory of all your assets at the time you passed away, what those assets are worth. They determine if there's any debts or expenses left to pay as they kind of work through the estate, and then ultimately how those remaining assets have to be distributed to your beneficiaries. And in your will, you will nominate an executor, which is the person that's responsible for carrying your estate through the probate. The probate process is anything but fun because it's dealing with court documents, getting things filed, getting it through, and unfortunately a lot of people underestimate how much time it actually gets through the process. Like in New York where we are, it's not uncommon for the probate process from start to finish to take 6 to 12 months. So it takes sometimes that long before the beneficiaries actually have access to the assets that they're inheriting. So part of the estate planning when we're sitting down with clients is, okay, how do we pass assets to your beneficiaries and avoid the probate process? Because the probate process comes with costs, because a lot of times you're hiring an attorney to help you through the process. You might be hiring accountants to do the final estate tax filing, or you're hiring appraisals to appraise like property. So there's all these expenses associated with the probate process. So usually the idea is if we can avoid it, that's typically ideal. Let me circle back now to that example we were talking about with the minor children coming into assets at age 18, because it's a common situation that parents are usually trying to navigate around. So this usually involves frequently setting up this testamentary trust. So a testamentary trust is actually a trust that's established within your will. So it's not something that's a separate trust that's set up like other type of trusts. You actually build the trust within your will and the terms of that trust. So if something happens to both parents, the assets of your estate essentially go into this trust, And then you've set up terms that say, my kids don't come into their inheritance at 18. Maybe they come into a third at 25, a third at age 30, a third at age 35. And within that testamentary trust language, you will designate a trustee that says, listen, if me and my wife run around, we have minor kids that are surviving us, maybe my brother is handling these trust assets and he's allowed to distribute assets for their educational expenses, health expenses, necessary living expenses, but it prevents my kids from going out and buying that Corvette at 18 because there's that safeguard set in place, even though they're going to be set to inherit those assets at those future age dates. But I do want to note that those testamentary trusts do not avoid the probate process like other trusts do. So since it's part of your will, all of your assets are still going through probate like we talked about, where other trusts, like a revocable trust, which is a living trust, or an irrevocable trust, those types of trusts typically do avoid probate for any assets that are in them, which makes them advantageous. And when you go to establish a revocable, irrevocable trust, you're actually establishing that trust today. So there's assets that can be owned by that trust, and when you eventually pass, like I said, avoids probate. If it's an irrevocable trust, it could reduce the size of your estate. It could protect your assets from a long-term care event. And also with those trusts, it allows you to maintain that control beyond that date of passing if you have beneficiaries or minor beneficiaries involved with your estate planning. There are some assets that you may own that actually pass outside of the will. Some of these assets pass by what's called by contract. So if you have like a 401k plan, an IRA, life insurance, usually on those accounts, you have designated specific beneficiaries which may or may not be the same as the ones listed as your will. So if you have a 401k account and you pass, they just pull that beneficiary form and say, okay, this is who it's being paid out to. There's no probate process because again, it's not passing by probate, it's passing by that contractual agreement within that account. Another type of account that passes by contract that is sometimes overlooked is called a transfer on death account, a TOD account. So it's not uncommon for individuals to have just plain vanilla individual brokerage accounts or joint brokerage accounts that are not retirement accounts, but they just own investments in them. But if I own a brokerage account just in my name and I pass away, that is part of my estate and it can go through the probate process. If all I do, so I can add a feature to that brokerage account, making it a TOD account, which now allows me to list beneficiaries, where now if I pass away and I have this brokerage account, which is now titled as a TOD account, they'll look at the beneficiaries, those assets do not have to go through the probate process and they get to be paid directly to the beneficiaries, which is usually advantageous. All right, let's shift gears over to the power of attorney document. Now, what this document allows someone to do, that if you become incapacitated for whatever reason, this document allows someone to step into your shoes and act as you financially. Let me give you a few examples as to how these power of attorney documents work. So if you were in a car accident and you ended up in a coma and you had bank accounts that were just in your name, credit cards that were just in your name, investment accounts that were just in your name, even though you may be married, because your spouse isn't listed on those accounts, they have no access to them. The financial institutions will not talk to them unless it's a joint account. So that can put a spouse in a tough situation that if they need to pay your bills or manage your accounts or get access to cash, unless their name is on that account, they can't. But if they're listed as your power of attorney, they can then step in as you and continue to manage your finances going forward until you work your way back to health. Another common situation where these power of attorney documents are used are with long-term care events. So if you have a family member that has a stroke, develops dementia, something that requires them to go into like a nursing home or assisted nursing facility, and they're no longer able to manage their finances themselves, that's a really important point where a family member or a power attorney is going to have to step in and manage their finances for them because they're going to have to pay for their care, for their medical bills. They may be going through the Medicaid application process, or they may be trying to shift assets to protect their assets from a Medicaid spend down, and that power of attorney document is what allows someone to step in to accomplish all of those things. I always make it a point when I talk about these power of attorney documents to state, you really have to trust the agent that you have designated within your power of attorney, because they have a lot of power. They can act as you financially when you become incapacitated. And being in the role of financial advisors, we have seen cases where that's been abused, because you can put within a power of attorney document that they're allowed to gift to themselves, gift to family members. So if all of a sudden you're incapacitated and they start gifting their assets to themselves, they could have the power to do that. So you just really have to trust that person, and you have to be aware of all the powers that you've given them within that document when you're working with that estate attorney. The third document we're going to talk about is a health proxy, another important document, because if you can't make health decisions for you yourself, who is stepping in and making those health decisions on your behalf? So the reason why we sometimes see people not have a health proxy is it's not the most comfortable document to complete. They're asking you questions like, would you want to be resuscitated? If you couldn't eat, would you want a feeding tube? Would you be willing to be put on life support? Like, these are really tough situations to put yourself in. But if you think about it, if it's really tough for you to answer these questions for yourself, if this document isn't in place, you have now put that responsibility on your family members, that you've had a major health event, you can't make decisions for yourself. So now your family members have to decide what you may have wanted, which is really difficult to do. And it can put a lot of emotional stress on a family trying to make those decisions if family members disagree. So we kind of say, while you are of sound body and mind, provide that guidance to your family and complete that health proxy. We also urge clients to keep their estate plan up to date. It usually makes sense to at least revisit your plan every 5 years. Now, you can update these anytime. I know you're making a lot of important decisions about health proxies and power of attorney, but if you change your mind about something or someone, you can update those documents at any point along the road. But the big thing for updating the estate documents is Congress sometimes changes the estate rules or the estate tax rules. And also, estate law varies from state to state. So it's different from New York, California, Florida. So if I move from New York and I establish permanent domicile in Florida, usually we're telling those clients that, hey, as soon as you get down there and get all situated, you should really meet with an estate attorney to update your estate documents since you plan to be there in Florida for the foreseeable future. We often get the cost question about establishing these estate documents. So if you're working with an estate attorney, which we normally recommend, if it's really just a simple will and that's all you're really looking to do, usually you're looking probably under $1,000 for something simple. Now, the cost of all these estate documents will vary based on the complexity. If you have a lot going on, a lot of moving pieces, it just makes it more expensive because there's a lot more the estate attorneys have to account for. If we're looking for all three documents, the core three, which is the will, the health proxy, the power of the attorney, you're probably looking somewhere between $1,000 and $3,000, which that number sometimes scares people a little bit. They're like, wow, that's really expensive just for some estate documents. But I always urge people to say, think about the cost of not doing them. Like, there is cost associated with not having these documents. So if you don't have these documents, you got to go through potentially a long, expensive probate process, which you're paying attorneys, accountants, appraisers, court fees, filing documents, all that, which could cost thousands of dollars. Or if there's a flaw in your estate plan, your beneficiaries might have to pay tens of thousands of dollars in taxes that could have been avoided if the estate plan was structured correctly. So there's all these additional costs, and the biggest one of all with that healthcare proxy, just the emotional strain it puts on the family members if they don't have a clear picture as your health decisions, your financial decisions, and the family has to figure out amongst themselves. It's much easier if it's more black and white. This is what mom or dad or their friend wanted when they're processing through the estate. I hope this was helpful. If you have any questions, please feel free to reach out to us at moneysmartboard.com. Thank you.